The Constitutional Court will hear two applications challenging the Electoral Amendment Act. The amendments will see independent candidates contest elections, both nationally and provincially, outside of political parties. Let's cross back to our news senior reporter, Canny Maphanga, who is at the Constitutional Court and, of course, been watching this one for us. So, Canny, perhaps, just taking a look at the background once more to the constitutional challenge to the Electoral Act and, of course, what this means today.
Well, good morning to you, Sakina, and the viewers at home. And as we wait for some of these interested parties to trickle their way in to the Apex Court ahead of the 10 a.m. hearing, it's an opportune time for us to speak about what brings us here today at the ConCourt. You may remember the landmark New Nation Movement case where they approached the Constitutional Court to challenge the Electoral Act insofar as it didn't allow independent candidates to contest elections beyond the local government elections, i.e. in the national and provincial elections. They were successful in their bid to declare that invalidity, and the National Assembly was given 24 months to remedy the defect. Now, what we're dealing with here is the remedy, the amendments that were made to the Electoral Amendment Act, which the independent candidates are going to argue that it isn't fair to them. Now, we understand that some of the amendments they're looking at is the signature requirement as well as the seat allocation with respect to the National Assembly. We know that they will argue that this 50-50 split for the 400 seats, which will be between the regional seats and compensatory seats, is not fair because it will result in an effect where we will see political parties contesting for 400 seats and independents only contesting for 200, giving the independents an unfair disadvantage and the political parties an unfair advantage in the elections, the national and provincial elections rather. And then, of course, there'll be the argument regarding the signature requirement. The amendment has created a 15% threshold, which the applicants will argue that it creates these walls or builds these wall-ups for new entrants to contest the election. So basically, they want to come up with an electoral system or amendments that creates an electoral system that is fit for purpose and will result in fair and free elections as envisioned by the Constitution, which really speaks to the core heart of a constitutional democracy, is ensuring that those elections are fair for all who want to compete as well as all who want to be represented in South Africa.